Cathaoirleach. Again, I want to congratulate the Minister on her appointment and wish her well. There's much in this legislation which is useful and necessary. Of that there is no doubt. And I accept what my colleague Deputy O'Callaghan has said in relation to remote hearings, etc., that the courts, under their own rules of proceeding, to do this sort of thing already, and I welcome that. But it is quite useful, and I welcome the fact that it's now being put on a statutory basis. There are some provisions in the legislation which I welcome because they are urgently needed because of the COVID crisis. But I don't think that sections 13 and 14 are urgently needed. I mean, the whole legislation is presented as a package which is urgently needed. There's a part of it, a section in it, which is not urgently needed and which, in my view, should require and would require more considered debate. I listened to what the Minister said about the Law Reform Commission and the judgments of the Court of Appeal. I've looked at those judgments and I've read the relevant section of the Law Reform Commission report. And the Law Reform Commission, neither the Law Reform Commission nor the Court of Appeal judges have indicated that this legislation is either necessary in its present form or urgent. They did indicate that some changes were necessary, but certainly they did not indicate that a change of this magnitude was necessary. Because what the section states, if you go back and look at the section, what it states is that any record in document form completed in the ordinary course of business shall be presumed to be admissible as evidence of the truth of the fact or facts contained in such a document. Now that is a very, very fundamental change in the law. And who does it benefit? We've heard suggestions that it benefits vulture funds. It does, but it benefits more than vulture funds. It certainly benefits vulture funds, but it benefits more. It benefits anybody who is preparing business documents in the ordinary course of their business. In other words, it is indisputably on the side of the heavy hitters, and it does. I agree with Deputy O'Callaghan that the court must take their own view in light of all the evidence presented. But there is no doubt, there is absolutely no doubt whatsoever that this does tilt the balance very significantly in favour of the person who is presenting this hearsay evidence in documentary form. And you know, the more I read the section, the more I'm convinced that it is rushed legislation. For example, I'd like to ask the Minister what section 14(1)(c) actually means. It reads, in the case of information in non-legible form that has been reproduced in permanent legible form, was reproduced in the case of the normal operation of the reproduction system concerned. Now, there's obviously something missing there. I think that would need some redrafting. Section 14(2) of the legislation provides that the section shall apply where the information was supposed directly or indirectly, was supplied directly or indirectly, but if it was supplied indirectly, only if each person to whom it was supplied received it in the ordinary course of a business, whether or not he or she is identifiable. I mean, how can you say that they received it in the ordinary course of a business if they're not even identifiable? I mean, this has all the hallmarks of rushed legislation. I don't know what the objective is. I don't know why it was included parcelled in here amongst very necessary legislation. But I think it is not. I would appeal to the Minister. I would appeal to her to withdraw this part of the legislation because it does require greater study and greater scrutiny. It is going to have wide-ranging effects. It is going to fundamentally tilt the balance in favour of businesses before the courts, as opposed to what Deputy McGuinness referred to as lay litigants. And I would say to the Minister, you know, I have to agree with Deputy McGuinness, there are echoes here of what happened recently. I mean, I was very much in favour of the Higher Education Bill and I voted for it, but I didn't want to vote for the section that increased the pay of a super junior minister by €16,000 at a time when the country is facing into a crisis as a result of the outfall of the pandemic. I didn't want to do that, but if I was voting for the bill, I had no choice. And if I had been a member of the government, or if I had been advising the government, I would have advised them strongly to leave that section out. And I'm advising the Minister tonight to leave this section out, because, you know, if this section is included in the bill, I will certainly be voting for the bill, but with the greatest reluctance. I don't want to be put in this position on a permanent basis, and I'm not going to accept being put in this position on a permanent basis. There is no reason whatsoever why this section should be included in this legislation at this time, and I would respectfully ask the Minister now to withdraw it so that it can get proper scrutiny, and it needs proper scrutiny because it is going to have the most widespread implications from this day forward.
Deputy.
Thank you.